Hello everyone and Assalamualaikum warahmatullahi wabarakatuh. My name is Putri Rananda and my matric number is 27591 and 5. Now I will talking about fake of the case. The court state there is a question of law whether agency contracts may be cancelled or are irrevocable. Even if the parties plan to create an irreversible agency with interest, they must actually form the agency with the interest. The principle of owner maintains the ability to revoke the agency if they have not constituted a lawful agency with interest. The court may assess damage if the revocation is contractually unjustifiable. Now I will talking about issues of the case about contract law. Uh, in this year 1995 until 1998, the court revisited the legality of a cancellation of a hotel management contract that had been intended by the parties to be irrevocable in a manner initially handled in the District Court of the Virgin Islands. As a part of Scotiabank's bailout, the property was transferred to the Finnish Government Guarantee Fund, or the original lender. The property was eventually sold to 35 Acres Associates by the Finnish Government Guarantee Fund. And 8 June 1995, great crash by development company include and Hyatt Corporation as invalid, terminated, or expired. 35 acres as the Hyatt immediately surrender control of the hotel to them on 8 June 1995. And then the 35 acres associates, the property's owner, feel sweet and Hyatt responded with a counterclaim. On appeal, the court state, regardless of the final conclusion of the other litigation, the conclusion of the other litigation is the parties agreed that this appeal focuses exclusively on 35 Acre's ability to terminate the agency, and it is right to ownership of the hotel and related property as well as transition consideration. As a result, we don't assess whether 35 Acres misable Hyatt's management rights. Okay, maybe that's all from me. Thank you.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Mohidin Amadionur Rahmat, metric number 27591, and I will be talking about holding of the case. Dated on 10th of April 1996, it is hereby ordered that Hyatt Corporation's motion to dismiss the First Amendment complaint in Government Guarantee Fund versus Hyatt Corporation is denied without prejudice. It is further ordered that 35 acres Associates' motion for partial summary judgment in Government Guarantee Fund versus Hyatt Corp is granted. Both parties shall work together to effect a smooth transition in the management and operation of the hotel. It is also ordered that Hyatt Corporation's motion to amend the court's order of January 8, 1996 is denied. Hyatt shall have 10 days from the entry of this order to answer the first amended complaint in Government Guarantee Fund versus Hyatt Corp. and assert any defense's compulsory counterclaims thereto. It is hereby Hyatt Corporation's motion to dismiss First Amendment complaint denied without prejudice and 35 Acres Associates motion for partial summary judgment is granted. Hyatt Corporation's motion to amend court's order of January 8, 1996 denied, then case is closed.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Hakim Karminita Aurelia with medic number 281413. And now I will present about rationale of the holdings. In the GGF suit 35 occurs 6 determination that is agency relationship with Hyatt has been terminated as a matter of law, and Hyatt must leave the premises. It is undisputed that 35 Acres is the owner of the hotel and successor in interest to Great Crest by Development under the management agreement of March 9, 1990. It is equally undisputed that 35 Acres gave notice of termination of the agency by letter of March 21, 1995, and again on June 8, 1995, by its own admission, Hyatt has no proprietary interest in the rest itself, nor is there any claim that the agency was created for the benefit of a third party. And Hyatt's Rule 59 motion to amend in the Hyatt suit. In its Rule 15 and 59 motion, Hyatt asks this court to amend its order of January 8 to allow it to file a third amended complaint. Since we find that Hyatt's claim against the GGF parties properly should be asserted as a compulsory counterclaim in the GGF suit, this motion will be denied. Rule 13a defines a compulsory counterclaim as one that arises out of the transaction of occurrence that is the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction.
Now to conclude our presentation, this court finds that as a matter of law, Hyatt was not wrongfully terminated by 35 acres because Hyatt was in breach of his obligation to remit payments of base debt to Scop Bank. Hyatt's argument why it was not obligated to make such payments are contradicted by the express terms of relevant agreements. Hyatt's claim that the termination constituted bad faith is without merit. Hyatt's claim for breach of the guarantee also fails because there is no evidence that such a breach caused any damages to Hyatt. Accordingly, counts 1, 3, and 10 of Hyatt's counterclaims are dismissed. All that remains are the claims of Scop Bank, 35 acres, 12 acres, and Benifori Oy against Hyatt.